court. In any case, the arguments mentioned here are not valid to question the authority of judges because of their national belonging. And this is the argument of the defense. I request the court to reject the argument, and if I succeed to reply and to answer the other arguments about the authority of the court. The authority of judges because of their national belonging. And this is the argument of the defense. I request the court to reject the argument, and if I succeed to reply and to answer the other arguments about the authority of the court. Then there is no fault with the fact that a Jewish judge will sit in judgment on a persecutor of the Jewish nation. On the contrary, it is good that there is a place in the whole world where Jews have sovereignty, their own courts, a prosecution, and the possibility to bring to judgment a man who has committed crimes against this people. Too late.
Jawohl, ich habe es verstanden.
I understood. Before I begin analyzing the documents, too late.
Jawohl, ich habe es verstanden.
I understood. Before I begin analyzing the documents, I wish to touch upon a question raised by the defense, and this is the difficulty of preparing the defense because of the fact that the case is being conducted in Israel, and he cannot, as he says, bring his witnesses to Israel. Some of them fear for their own security, and others, there is no one to finance their travel and their stay in Israel. In a previous conversation with the defense, I have informed him that I shall recommend to the court, although the decision lies with the court, that affidavits will be presented as evidence, and if the defense has people who are ready to come and be witnesses. I shall not block the way, I shall not put any obstacles, and although I shall not have the privilege of cross-examining those witnesses, I shall agree to admit such affidavits, of course, after discussing the question of the relevancy of such affidavits. I am also ready. You say in general that you are ready to accept affidavits from witnesses for the defense now abroad and to forego your right to cross-examine.
Of Kenyan County in violation of the Constitution and laws of the United States. As was done in the Supreme Court of Idaho, the accused set up numerous facts and circumstances which he contended showed that his personal presence in Idaho was secured by fraud and connivance on the part of the executive officers and agents of both Idaho and Colorado in violation of the constitutional and statutory provisions relating to fugitives from justice. Consequently, it was argued, the court in Idaho, תודה.
אני מבקש לא לצחוק.
Did not acquire jurisdiction over his person.
Anybody who's going to laugh will be expelled from the courtroom.
Consequently, it was argued the court in Idaho did not acquire jurisdiction over his person.
States and between the United States and other countries, then the same principle will apply and in the same force in this court of law. Adolf Eichmann is here before you legally by for his arrest legally issued. He was presented with the indictment as is required by the law. The indictment is drawn up according to the law. And the offenses he's charged by are crimes according to the law of this state. He has been given the chance to prepare his defense. He will be given a full opportunity to defend himself if he has what to say in his defense. And the circumstances in which he was brought to court is not a matter for this court to discuss. They are irrelevant. Therefore, I request, without calling the witnesses, the defense named this morning, because their testimony will throw no light on any problem which this court is called upon to answer. Their testimony will throw no light on his being guilty or not guilty, according to one of the offenses in the indictment, and this is the only relevant matter.